We in the Second Amendment community are seeing a lot of lawsuits now after the NYSERPA versus Bruin victory in the Supreme Court. A lot of these lawsuits we hope are going to go very well in expanding the right to keep and bear arms all across America more and more. Some of these lawsuits may fail, and a lot of them may fail for technical reasons, such as a lack of standing, a lack of subject matter jurisdiction, the wrong plaintiffs being dismissed, who knows what. So I thought, in light of all these lawsuits, I would give you some real-world practical applications of how public interest lawyers pick plaintiffs and how to think about who are the best plaintiffs for these kinds of high-profile Second Amendment or constitutional challenges. Because often, who you pick as your plaintiff is the difference between winning and losing. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, best-selling author, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. All right, folks, we are seeing a lot of litigation involving the Second Amendment. And remember, part of what I want to do here is to make you extra smart about some of the inside baseball, the inside tricks of the trade that go into winning for the Second Amendment. And one of those critical things I want to talk about is how do organizations or people that want to bring lawsuits on behalf of any constitutional right or any public interest case, how do they pick their plaintiffs? How do you figure out who is a good plaintiff to sue and who would be a bad plaintiff to sue? And some of the other considerations that professional public interest lawyers consider before bringing a lawsuit in terms of who represents the case. To begin with, the first basic principle when you bring a lawsuit for a public interest challenge is you want to, generally speaking, bring the case as a civil matter, not in the context of a criminal case. Let me clarify what that means. There's two types of cases. Sometimes they can be in front of the same judge, or a judge can handle both civil and criminal cases. Federal judges do this all the time. There are civil cases. Now, civil cases involve what are known as lawsuits, often for money, but in the context of the Second Amendment, what they're usually about is for injunctive relief, which basically you want a court to say to the government, I am enjoining you, I am stopping you from enforcing that law because that law violates, for example, the Constitution and the Second Amendment. So it's not enforceable. I'm hereby entering an order that says the government may not enforce this restriction on gun rights for whatever reason under the Second Amendment. Here it is. That's usually what you want, a civil lawsuit. But remember, there are also cases that involve criminal matters. And what a criminal matter is that you run the risk of going to jail. It's a criminal penalty. You can become a felon. And if you're declared a felon or you're convicted of a felony, you lose your gun rights for the rest of your life for all practical purposes. And of course, you could go to jail, lose your liberty, lose a lot of money. All sorts of terrible things can occur, including losing like a law license or a professional license or all sorts of things like that. So criminal often is viewed as very bad. Civil is bad as well if getting embroiled in a civil lawsuit, but obviously being convicted of a crime is terrible, and people want to avoid that at just about all costs, of course. So I bring this up because Second Amendment cases can arise in either context, of course. For example, someone who's actually arrested for improperly bringing a gun in a quote-unquote gun-free zone or sensitive place is being charged with a crime. So certainly you would assert the Second Amendment there. By the way, that's what happened in the Caetano case in Massachusetts, where the woman who ultimately gave rise to the Caetano versus Massachusetts decision in 2016 by the U.S. Supreme Court that held that stun guns were commonly possessed by Americans for lawful purposes, and therefore they are protected arms. That came up in the context of Miss Caetano being charged with a crime under Massachusetts law for illegally possessing an improper stun gun. You weren't allowed to have stun guns back then under the law. She challenged it with a defense of the Second Amendment and went all the way up, and she actually won that. But generally speaking, that's not the best way of doing it for many reasons, one of which is you don't want to be representing someone who could go to jail. That's very stressful, obviously. Moreover, if you have an opportunity to settle the case or get out with a plea bargain, or that a government can just dismiss the case, that's a very good result for that particular person, of course. But it doesn't set the legal precedent that the Second Amendment community might want to set for future cases and future things. In other words, if you looks like you're going to win a criminal case, the government might just drop that case, which again is a great result for the individual criminal defendant, but it doesn't create the legal precedent that we can use to move forward and advance the Second Amendment right. So usually when you're trying to affect constitutional rights, you want to do it in the context of a civil lawsuit that you control as the plaintiff, because you determine whether or not to settle the case, whether or not to push forward or not. So you don't have to worry about, getting your case dismissed willy-nilly, because you control the litigation to a large degree because you're the one suing. And if you don't want to settle the case, then you don't have to settle it as a general matter. So that's the first thing. You want to bring these cases in the context of civil cases, not criminal. So the first thing is you want to be bringing lawsuits as opposed to representing people in criminal cases. Not to say that you would never assert Second Amendment cases in the criminal context or want to have some representation there. I'm not suggesting that at all. But generally speaking, civil is better than criminal for the purposes of changing and effectuating legal change with the Constitution. That's the first point. The second point I want to make for those people thinking about bringing lawsuits or how to think about this is, who are the plaintiffs? But before we talk about who should the plaintiffs be, let's talk more generally. We actually want more than one plaintiff. What do I mean by that? When you bring a lawsuit in a public interest context, the more, as a general rule, the more plaintiffs you have, the better. Why is that? Well, lawsuits can go on for many years, right? They can go for 3, 4, 5, 6, 7, 8 years. And in that time, if you only have a single plaintiff, right, guess what could happen? What if that plaintiff dies? What if that plaintiff moves out of state? What if something happens to that plaintiff that's embarrassing and they just quit because they don't want to be involved anymore? What if you get into taking their deposition and it turns out there's something in their past that's very bad that you don't want to get out there? What if they have to take the Fifth Amendment and not testify for some reason? All these things can occur with any individual. So you want to spread your bet, if you will. So it's generally speaking, if you can, to have multiple plaintiffs suing, because obviously if you bring a lawsuit where you have 6 or 7 or 8 or 9 plaintiffs, what are the odds of all 9 of these plaintiffs having some sort of problem that would prevent the case from going forward, or all 9 of them dropping out between the time you start the case and the time the case is ultimately completed, let's say going all the way to the U.S. Supreme Court? So generally speaking, you want to have multiple plaintiffs and not just 1 or 2, because again, things happen, life intervenes, people drop out, people die. So you want to account for that, because if you only have 1 or 2 plaintiffs and they both die, or one dies and moves out of state, well, you basically have lost your lawsuit and have accomplished nothing. And now you got to go back to the beginning and start the whole process again. And you could lose years of your time and money advancing a case that winds up going back to the start square, if you will. And you don't want that. So again, number 1 is you want to go with civil lawsuit, generally speaking. Number 2 is you want to have multiple plaintiffs. So the third thing to consider are, who exactly should these plaintiffs be? Well, these are plaintiffs that need to have standing. And there's really 3 components for your purposes to think about that for a plaintiff to have standing, for a person to have standing. Number 1 is they have to suffer an injury, or they have to be on the verge of suffering injury because of the new law. For example, let's say I have a carry permit in New York City and I've had it for 20 years, and all of a sudden New York passes a law that says I can no longer go into my office building. They've now declared it a gun-free zone. So here I've spent 20 years going into my diamond shop on 42nd Street or my office building at Rockefeller Center, or whatever it is, and all of a sudden I'm now banned from carrying that gun. So now I'm being hurt because either I'm going to risk going to jail by committing a felony by going somewhere with a gun that I'm not allowed to go, or I can't bring my gun anymore, which deprives me, of my Second Amendment rights. That would be an example where I've been hurt, and who does the hurting? Well, the person who's hurting me is, again, you have to sue the right person, would be presumably the people responsible for enforcing the law against me, because those are the ones I want to enjoin, meaning stop or prevent from enforcing the law, because they're the ones that can enforce the law against me and put me in jail if I violate the law. Last but not least is the case has to be something that a court can remedy. Obviously, a court can always remedy a Second Amendment case by virtue of just telling the government not to enforce the law that infringes the Second Amendment. So again, number 1, civil lawsuit. Number 2, multiple plaintiffs. Number 3, you want to make sure that each of those plaintiffs has standing. Now, here's a little bit of a tricky thing to keep in mind. Now, for example, if you're going to sue in the state of New York, there's different laws that you might challenge. A single lawsuit can challenge more than one law. Let me give you an example. So we know that New York, for example, if you don't have a carry permit and you want to get a carry permit, right now you have to provide information about 3 years of social media account information. So that's an example of a law that exists in New York today. Another law is, well, they have defined Times Square as a sensitive place, gun-free zone. So that's another law there. And the third kind of law is that we want 4 references from 4 friends. So those are three types of laws. Now let's talk about the types of plaintiffs. The same type of plaintiff that's very good for the sensitive places law challenge may be a completely different plaintiff than who you would want to challenge the social media account part of the law, and could be an entirely different plaintiff than the person that you want to challenge the four references. Let me give you an example. If I were representing an organization, or I was trying to bring a Second Amendment case against those three New York laws, here's how I would do it. I would want to find one plaintiff that has a gun permit right now, that wants to go through Times Square, has gone through Times Square in the past, but now is not able to because they've just declared it a gun-free zone. And I would use a person like that as a plaintiff to challenge the gun-free zone Times Square rule, because again, he's clearly been hurt because he's not allowed to go through there anymore with his gun like he always had in the past. We know who's enforcing it, which is NYPD and other people in the state of New York that enforce the laws. And last but not least, we know that a court has the ability to remedy it by enjoining the law, saying that you can walk through with your gun going forward. That's not legal. So that would be one type of plaintiff. Now let's talk about the other law here, the social media law. So the social media law says under New York, you have to provide information about your social media accounts going back 3 years. But that only applies to new applicants for concealed carry permits. So if I've had a concealed carry permit for 10 years, I'm not going to be subject to that law, so I can't sue because I'm not being hurt by the law, so I would not have standing to challenge the social media component law. But let's say I found a plaintiff who wants a concealed carry permit and has never had one, so that person will be able to apply for a carry permit and will say, look, I want to apply for a carry permit, but I don't want to disclose all my social media information. I think that violates my First Amendment, among other things, and my right to privacy, et cetera, et cetera. So now that's a different plaintiff from the first one. The first plaintiff had a gun permit for many years and challenged the sensitive places law. The second person would be able to challenge I don't want to turn over my social media accounts because that's violates various Fifth Amendment, First Amendment, on and on. So that would be a different type of plaintiff. So in that lawsuit, I would already have two different plaintiffs, one that has a gun permit for many years, one that wants a gun permit but doesn't want to turn over social media accounts. Now, let's talk about that third law we were just discussing, how it might work. So the third law I just mentioned is a four personal references rule. They need references from four people that you know in the state that are not law enforcement to say that you're a good person, you have good moral character. But let's talk about that. What if the perfect plaintiff, in my view, for something like that would be someone perhaps who just moved to the state. Let's say someone is in California, they're an upstanding lawyer or professional or plumber or what have you, and they moved to New York because they just got married and that's where their wife lives or what have you, and now they want to apply for a carry permit, but guess what? They're brand new to the state of New York and they don't have four friends that they can go to and ask for a reference for a gun permit because they don't know four people. So now that would be a third type of plaintiff that I would want to add to my lawsuit, because that would be the kind of person that says, look, I got a perfect record. I've never been arrested. Nothing bad's ever happened in my entire life. But I just moved to New York. How am I going to find four references? I don't even know four people in the entire state of New York because I just moved here. Or maybe I just got out of the military and I moved to New York and I'm starting my new life. And now I can't exercise my Second Amendment rights because I can't find four people that I know for long enough to sign off on my gun permit as references. So that's an example of a single lawsuit challenging three different types of laws in the state of New York that if I were handling a case like that, I would want three different types of plaintiffs all in the same case. Again, that illustrates the point. Again, remember, as we've gone over this, civil lawsuit, multiple plaintiffs, and you want to make sure that each plaintiff has standing. And the fourth lesson is that sometimes you may have multiple plaintiffs in a case, and each plaintiff will have standing vis-a-vis a different kind of law that you're challenging, all within the same context of the same lawsuit. So you want to be very careful and very precise which plaintiff is challenging which law or laws, and which other plaintiff is suing over which law or laws, and they may not be the same, they may be different, but you need to think about this as a gestalt, if you will, in comprehensive totality to make sure you touch every base as a public interest lawyer. This is how I would be thinking about that. Now, the next point is, I would say, you want to make sure when you pick your plaintiff, it's a sympathetic plaintiff. In the Heller versus District of Columbia case, the plaintiff is a man named Dick Heller, a great American. This is a person who is a former veteran. He was, I believe, a security guard, a perfect record, again, former military, upstanding person in all respect, nothing negative in his background whatsoever. He was articulate. He looked good on television. He talked well in the press. There was no bad facts about him or anything like this. And by the way, I want to let you know in the Heller versus the District of Columbia case, which gave rise to the Heller decision, which says we have a right to have a gun in the home and says that we have an individual right to keep and bear arms under the Second Amendment. That was a really big deal because that case actually started out, as I recall, with multiple plaintiffs, by the way. And the only plaintiff left standing at the very end of the case when it went to the U.S. Supreme Court was Dick Heller. So thank God they picked Dick Heller because the other plaintiffs, as I understand it, fell by the wayside over the years for one reason or another. So that's another example of why you need more than one plaintiff. And when you do pick a plaintiff, you want to make sure there's nothing bad about them, because if there's something bad about them or something you can Google and find or some terrible criminal record, obviously that's the sort of thing that the press can hold against you, and it could sway judges. You just never know what's going to sway a judge one way or the other, especially in a close call. Who you pick as a plaintiff is not just making sure you have your legal I's dotted and your T's crossed. It's also making sure from a PR point of view, you don't want to have someone suing that's going to, blow up on you when someone Googles the person or someone does some research on them and they turn out to have some terrible thing in their background that's going to make the entire Second Amendment movement look terrible. And you don't want that, because it's also going to make it harder to win that case, because people want to rule in favor of sympathetic plaintiffs. It's human nature, and we should always be aware that even though judges are supposed to follow the law, and they usually try to follow the law, we have to recognize that judges are people too, and we want to seize every inch we can, and having a sympathetic plaintiff is another inch that we can seize in the Second Amendment community as we move the ball forward. Okay, I hope you learned a little bit something about how lawyers pick plaintiffs, the different considerations to go into this, both for individuals as well as organizations. I know it's a little geeky, a little nerdy in terms of this inside baseball we sometimes cover, but again, that's what I really want you to understand, these details, because I think it makes the whole movement smarter and better to really understand the inner workings of the court system, because the court system is so important to protecting our right to keep and bear arms here in America. Okay, again, if you haven't subscribed to the Four Boxes Diner, you better do so. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.